Senate.
Order, members.
As directed, we proceed to respond to the charges brought against the governor of Kiambu County. On the record of the Senate, the governor had filed a notice of preliminary objection that raised 4 points of law. As part of the governor's response, we shall proceed to urge the said PO, and I shall start, and then my colleagues will argue the other two grounds, the second ground. Let me begin by stating that the governor pleaded not guilty to the charges. What is the effect of a plea of not guilty in this kind of proceedings? The effect of a plea of not guilty in this kind of proceedings, which are quasi-judicial, is that the burden immediately shifts to the county assembly to prove all the material particulars of the charges. We say that in particular respect because one of the material particulars they are supposed to demonstrate is that before the Senate there is a valid motion, there is a valid resolution, there is a valid process that properly and in a manner provided for by law activated the jurisdiction of the Senate. The county assembly must demonstrate that the process that the Senate is called upon to interrogate, to hear and determine charges was proper from the time of its inception. Because without that lack of demonstration, then there is the risk and possibility that the Senate is sitting on an unconstitutional motion. Allow me to make reference to the determination, a decision of the court made by the late Justice Onguto in the case of Mwangi Iria versus Murang'a County Assembly. It's a reported case. And paragraph 92 of that decision, the court said, the Senate must also interrogate the entire process as it's carried through the county assembly. I have seen no law that restrains the Senate from returning a verdict, but the process was not conducted as detailed under the Constitution, or any law for that matter. The Senate must consider the process as it went through the motions in the county assembly. Why do I say that? Because in the recitals read by the Speaker of this House on the material that was presented by the county assembly to the Senate, you will notice at the outset that one of the documents that were not provided, you were given a notice of motion, you were given an order paper, but you were not given a list of the members who voted in support of the resolution. That is a document that admittedly, and even by reference to the record, is absent. The second important fact that I want to refer to is that there was an admission by the witness of the county assembly, that that is information that was not brought to the Senate. And why is it material to us? With the County Governments Act. We have determined as the people of Kenya and our Constitution that we are a democratic nation that observes the principles of democratic governance. What is democratic governance? Democratic governance relates to validation of any act, any appointment, any resolution by a number threshold. Honorable senators, you are senators because of numbers. You won an election. The President of the Republic is the President because of numbers. In the Constitution, there is a litany of many enactments that are validated by certain number thresholds, even in this Senate. For example, and just by way of illustration, Article 115 on the question of budget and the veto of the president. There is clear prescription of a 2/3 majority for Senate or Parliament to veto such a recommendation. So, back to our case. What are the numbers required to pass a resolution impeaching the governor at the county assembly? Section 33 provides, at section 33, subsection 3, subsection 2, if a motion under subsection 1 is supported by at least 2/3 of all the members in the county assembly. If a motion is supported by at least 2/3, that is when it becomes a resolution in the context of section 33, capable of activating the jurisdiction of the Senate. If such a motion, however well prosecuted or argued, or however well meritorious an assembly may think it is, but short of the 2/3 majority, it does not result to a motion that is tenable and sustainable, and in the context of section 33, can be capable of activating the process of removing a governor. What are the facts? What are the facts in this matter? And I say, and I speak to these facts, referring also to the investigative mandate of the Senate. The Senate, as earlier illustrated, has an investigative mandate. What is to investigate? It is to interrogate, to call, to look for, to search for the truth independently. The Senate has power to summon under the rules. Power to summon, it extends to the investigative mandate of the Senate. So part of the information that is available to the Senate to look at is the question of how many members participated in the passing of this resolution. It is our submission that this is a burden that is supposed to be demonstrated by the county assembly. Once you put in a preliminary objection impugning the validity of the resolution, then the burden shifts to the county assembly to demonstrate that indeed the number threshold was achieved. In making this submission, the following facts are relevant. 35 members of the county assembly were not in the county assembly on the 19th of December 2019. This is a fact that can be independently verified by the Senate. This is a fact that Senate can call the county assembly into account because attendance of an August House of any parliament is a documented fact. It cannot be left to conjecture, speculation, and equivocation. It is a fact that is put on record by way of a Hansard, by way of a biometric log, or by way of a register. This is public information that the Senate has capacity to take judicial notice of under the Evidence Act. It will be a sad day for the Senate and for the country if the Senate says we cannot inquire into the proceedings of the county assembly as we hear an impeachment motion. What then that means is that 3 members of the county assembly can wake up one day and bring a resolution to the Senate and say, quickly convene and hear these charges. Far from it. The duty of the Constitution, the duty of the Senate under the Constitution and Article 96 is to protect counties and their institutions and their people. Part of this protection is interrogating what goes on in the county assembly and all the organs set out in the Constitution. You will see that the report of the Speaker says there were 64 members. It is very easy, and nothing could have been easier than to provide a list of these 64 members who were present in the House on that day. That was not given. There's nothing easier than providing a list of the 63 members who purportedly voted in support of the resolution and saying, these are the members who under Section 33(2) supported the motion. We have at our disposal on the evidence that the directions were that it should not be admitted, but it is within the governor's knowledge that 35 members of the county assembly were not present. 33 of them have sworn affidavits, which they can be cross-examined on in any forum, not even in the Senate, even in court, and they have said we were not in the county assembly. That is a material fact. It cannot be ignored, it cannot be avoided, it cannot be glossed over. This Senate has a responsibility to the people of Kiambu, to the nation, to confirm what happened. Was there a fraud of the assembly upon the Senate? Our submission is, in the full evaluation of facts, we will find that the governor of Kiambu County was not impeached at the county assembly. The motion and the resolution that found its way to the Senate is untenable and unsustainable to the effect that it should be dismissed at the threshold. It is very easy for the Senate in its investigative mandate to call for even the CCTV records of the county assembly. It is our submission that this is a duty that in the past the Senate has dutifully and willingly carried out. In the special committee of this Senate convened to investigate the matter of Honorable Mwangi Wairia, there arose the question of whether the governor was heard at the county assembly. The plea by the county assembly was, that is not a matter that the Senate should investigate. The Senate should just look at the motion, the resolution, and proceed. But this House said, no. We want to see the Hansard. We want to look at the invitation to the governor. We want to look at the process at the county assembly. And this report is within your records. And in the fullness of that evaluation, unfortunately, in that case, the Senate found that the governor had been properly notified. But the point I'm making is that Senate took time to call for facts and investigate that matter that was raised in the course of proceedings. It is in the report at page 75. In fact, Senate said that we as a special committee have a duty, and it's incumbent upon us to determine if there was any violation of the Constitution at the county assembly level. You're being told today, ignore the county assembly process, let's deal with what we have. That is not what the Constitution and the law provides. I urge you, honorable members, I urge you, senators, in your fairness to the governor, you have to interrogate this very material fact. And you must make a decision as to whether you are properly activated, you are properly seized of this matter. Because if you found that the number threshold was not attained, then the matter rests there. You have to down your tools because you are improperly moved by the county assembly to a process that has certain minimum statutory and constitutional prescriptions. The Senate, similarly in the matter of Professor Kiprono Chepuni, which I had also occasion to appear for the county assembly, an issue arose and was raised by the governor on the question of whether or not there was public participation at the county assembly. And the Senate committee said, we cannot ignore that fact. It is an issue that affects the constitutionality of the resolution that you have brought to us. We must investigate it. And the Senate, if you look at that report, it's I think, 115 pages report. The Senate went into material detail, calling evidence, summoning persons to confirm whether or not there was public participation at the county assembly level. Because the effect or default thereof impugns directly the validity of the resolution, to the effect that the governor was not properly removed or impeached at the county assembly level. And therefore, in this matter of Governor Waititu, there may be many arguments, many allegations, many issues raised by the county assembly. Fair enough, it is their right. It is their right to want to remove the governor. It is the right of the Senate to hear and determine those charges. But it is also the right of Governor Waititu to receive the benefit of the law and due process. If you do not owe him anything else, you owe him that. The standard of the law and due process has to be applied not for the benefit of the governor, not for the benefit of the Senate, but for the institution of the rule of law that we have prescribed as a national value under Article 10. Yes, we may remove him, but let us remove him as the law prescribes. If the law says 2/3, we have to confirm that the 2/3 majority was attained. Numbers are democracy. And if those numbers were not attained at the county assembly level, then the resolution must fail. At the very least, we have to adhere to our constitutional principles, our constitutional standards, our precedents as the Senate. And I must say, I've been impressed by the Senate's insistence in all these reports on the adherence of the county assemblies on due process, threshold, nexus, and the standards that are now settled. In this matter, Governor Waititu, as a governor, under Article 27 of the Constitution, deserves equal protection of the law. That is a right that is available to him, and we urge in the fullness of your consideration of this issue. You cannot be told that lack of numbers is a technicality. It is not a technicality. That question was settled by the Supreme Court in Raila Odinga petition of 2013. that where the Constitution prescribes a number threshold, then that number threshold is not a technicality. It is a substantive issue that must be demonstrated by evidence. And therefore, arguments will be raised that we have not presented evidence in regard to this issue. There was an admission before this House that it cannot be verified independently, even by a member of the County Assembly who moved the motion, that the numbers required to be realized were realized. Where there is such doubt, can you move? Can you move? Where there is such doubt, can you move then to remove the governor on the basis of that resolution? Where there is that ambiguity, then the benefit of doubt must be given to the governor. I rest by saying, on this question, my colleague will take up the other preliminary issue, that inasmuch as this matter relates to Kiambu County, it will settle the law on this unique issue, because that issue has never arisen in any of the impeachment questions that have come before this assembly. The question of numbers has never arisen. It is unique to these proceedings. And this is the opportunity for the Senate to insist on the county assembly that the requirements of removal under Section 33, the 1/3 approval, the 2/3 support, must be strictly demonstrated before even such a resolution is admitted for hearing. Because it will be a sad day if we all gathered for 2-3 days to deliberate, discuss, and argue and determine a motion that is improperly before the House. That's why we raised this as a preliminary issue. It will be a manifest, unfair, and a very wasteful exercise if at the totality of the facts and the totality of the evidence demonstrated that indeed Senate was improperly moved. And therefore, honorable senators, it behoves this House, it is a responsibility that is given to you by the Constitution to investigate. To investigate. And I repeat, investigation for emphasis, that this is not a contestation between two parties alone. This is a contestation between two parties and an investigative organ properly constituted and the law. The Senate has capacity to even summon the clerk, summon the speaker, call for those logs, and demonstrate independently, even without our input, the integrity of the vote. The integrity of the vote. The issue of electoral and voter fraud is a live issue in this country. When it's raised, the Senate cannot prevaricate on it. It has to look at it, call for evidence, and what we have before you is an admission on two things. First, that detail, those particulars were not given to the House. Secondly, the mover of the motion and the witnesses of the County Assembly, even in the face of the preliminary objection, which they admit they were served with, and they knew that the issue of numbers was an issue in these proceedings, they did not lead any evidence. And the burden is theirs. Once a governor pleads not guilty, the burden is theirs to prove that the number threshold was realized. It cannot be a presumption. It cannot be assumed. It has to be demonstrated by evidence, empirical, admissible evidence, to a threshold as required by law. That demonstration, that evidence is absent. And in its absence, then the unavoidable conclusion, and this is my plea to the Senate, it must find that without that evidence, then there is no proper resolution upon which the Senate can move to determine whether or not